Now, you may at home not know the name Anthony Mangone, but I bet you know the people his testimony has helped convict. They include former state senators Nicholas Spano and Tom Libous. Also, Sandy Anabi, the former Yonkers City Councilwoman sent to federal prison for bribery. Now, Anabi accepted cash to vote in favor of the massive Ridge Hill development project, and that vote paved the way for the place to get built. Now, Mangone, a Westchester attorney in his own right, helped prosecutors in all those cases and more. But Mangone himself just got sentenced to 18 months in federal prison for his role in a corruption scheme that involved Anabi. So the question is, and again, the prosecution, they went to the judge with ask for leniency. So why didn't a cooperating witness and an attorney get some of that leniency? And going into this, I figured he'd find a sympathetic ear at the table, but not so much, Jimmy.
Well, first of all, he did get leniency.
Yes, he did.
His guidelines were upwards of 4 to 5 years. She gave him 18 months.
The prosecution, though, just to be clear, they were looking for him to get less than 18 months for what he gave him.
The prosecution gives a 5K 1.1 letter.
The defense lawyer wanted probation. They don't take a position here.
Colleen McMahon, federal judge he was in front of, is not listening to any prosecutor tell him what to give him. They'll listen to the 5K and the substantial assistance. But, you know, you said he's a cooperator and he's a lawyer. Well, those two things don't go together like that, because a lawyer in front of a judge is going to be held to a higher standard.
And you believe a lawyer should?
Oh, I absolutely do, especially when you look at the type of crimes he committed. Now, also understand, somebody's prior history is also involved here. He was implicated in criminal activity in Westchester County. He cut a great deal, got a misdemeanor from the Westchester County DA's office, kept his license, kept practicing, testified at a trial, and as soon as he left the courthouse began committing another host of crimes. And the judge looks at that very carefully. Now, mind you, other federal judges would have given him time served. Other federal judges would have given him a year and a day or a better sentence. He ran into the wrong judge.
Well, that's true, and that points up some fundamental unfairness in terms of what she did, although I happen to agree that it's an appropriate sentence here. There's reasonable expectations that you go into a sentencing with in our district, and this is the Southern District of New York. Elsewhere in the country, it's not uncommon for cooperators to get sentences like this at all. But in our district, it's very unusual for a cooperator in a white-collar case to get any kind of jail time at all. So this is contrary to the expectation that he had. This is a judge who some of us at this table have appeared in front of before. This is a judge who's a straight shooter, but who tends to shoot from the hip. I don't believe that it's appropriate to single out the lawyer and say he was the worst offender in a case where two lawmakers went to trial, lined their pockets, got 7 and 4 years. So, you know, it smacks of a little bit of disproportionateness.
Your old office has been involved with this attorney over the years, hasn't it?
Absolutely, and he was a key witness in a case against a gentleman named Dennis Wedra, and the jury acquitted Dennis Wedra. In fact, the jury met Mr. Wedra outside the county courthouse and embraced him, literally giving him hugs, saying that they believed that he was not the proper target. In fact, that Mr. Mangone should have been the proper target. And that was also concerning some voting irregularities during the election in 2000, which was a very contentious election. So when you stop and you look at all of this in the course of conduct, the criminal history points you would have received, because in federal court you receive criminal history points even if you don't get convicted for certain conduct. You may receive an adjournment in contemplation of dismissal and you could be eligible for some points. So when you look at all of these things, the judge can take the totality of who you are and use that as a basis to either enhance your sentence or if they find that it's a great history to give you a lesson.
Yeah, but if you get a sentence like this, it could be a disincentive for future cooperators.
Well, that's what I'm going to.
And they look for this. They need this to make cases.
You've been on both sides of this, former prosecutor. Bad case, as you guys can say, sometimes makes bad law. He certainly seems to be an unsympathetic figure that we're talking about. But let's say it was somebody else, and the prosecution says, all right, you know what? You go to bat for me for this. You give me names. You give me specifics. You be a cooperating witness in every true sense of the word, and I'm going to go to the judge. I'm going to go to bat for you, and I'm going to get you time served. I'm going to do my best to do that for you. Now, obviously, you're looking out for your own hide, but somebody will go making the assumption that the prosecution and the judge are probably both on the same page. Does it have to be a little bit more clear, or should it be a risk that you take once you decide to play ball with the prosecution?
It should be a risk, because it's for the prosecutor as well as the person who's testifying. If the prosecutor has the ability to make that cut, that deal, they're essentially sentencing the person that they're, having cooperate. The judge ultimately can say, listen, you made this deal. That's your deal. You got the convictions, but I'm not going to. I'm not going to do what you say. I have the ability to sentence them. This is a bad person, worse than you
Yeah,
think.
but the
and I'm gonna
prosecutor in
sentence
this
them that way.
case, if you go by that rationale, the prosecutor gets to have it both ways. Because if the prosecutor is the one dictating the sentence, they're going to get crushed on cross-examination at a trial by a defense lawyer to the tune of, oh, you're just saying what the government wants to hear. So the government gets the benefit of saying, oh, no, it's the judge that gets to decide the sentence. But then if they really don't make an earnest pitch for the judge to cut it to the bone, the defense, they get it both ways.
What
They
we're
get
missing,
that
though-
argument that they're not making up the sentence, and the defendant is left out. The cooperator is really left out to dry because he
But it
has
will
no
make the
protection at all.
prosecutor think twice, and it will make the cooperator's lawyer think twice before having him cooperate.
that
But
is
we
true.
also have to look
That
at
part of it
what
is
the
true, and it
people who
possibly-
he has testified against get in terms of their sentence. And we have to realize that he's not just some guy who's not involved in this case coming in as a good Samaritan to testify. If he doesn't, he's getting charged. And he's not getting 18 months if he's convicted. So that he's, in my opinion, really probably ultimately came out very well ahead of the game.
Well, he did. The
Very
bottom
well
line
ahead
is
of
he
the
still
game.
got
He just didn't get-
significantly.
he
It's just a
Yeah.
broader thing. When you read it, and again, you guys have intimate knowledge, both, the judge, many have had cases before, you even know the person in this
But
case that
some
we're
of the
talking
stuff she
about.
said was wacky. She said, I would sentence you as a career offender if I could. That's a life sentence. That's just nuts.
All right,
That's
all right.
personal
I wanna-
bias.
You also can't have cooperators,
Career
people
offender?
getting arrested, coming into the system, just
Yeah.
saying, oh, all I got to do is cooperate and get time served, and then
Yeah.
all of a sudden, it's very
Fair
easy
enough.
to tell a
Fair
prosecutor
enough.
what he wants to hear.
It just seems you're really rolling the dice. Maybe
When
that's the way it's
when you
supposed
get
to work.
that sort of judge who has her own peculiar views.
Let's try to get to this tea stuff. Coming up next here, I love to see where the table falls. I know where I think about this. Former football coach at USC fired after allegedly drinking on the job. And believe me, it didn't happen just once. He's now suing his former school for a cool $30 million. He claims discrimination because a drinking problem is a disability.